Welcome to the Daily Current Affairs by CivicCentre IAS, where we try to discuss the important articles from the Hindu, the Indian Express, and the PIB from the UPSC CSC Prelims perspective. Displayed are the list of articles which we are going to discuss in today's video. The first article of the day says that under the Namami Gange mission of 2.0, under the Ministry of Jal Shakti, completed of 4 key projects in the second quarter of the financial year 2024-25. Know that these projects located in Uttar Pradesh and Bihar are specifically aimed at preventing sewage from entering the river, improving water quality, and regenerating the rivers. Significantly, this initiative will help in maintaining the sanctity of the Ganga and its tributaries, which is a crucial step for the country. In this context, let us talk about Namami Gange Mission 2. See, the Namami Gange program was initiated in June 2014 to regenerate the Ganga River and its tributaries. Initially, it was scheduled to run until March 2021 with a budget of 20,000 crore rupees. Notably, given the scope of the program, Namami Gange Mission 2 has been approved with an increased budget of 22,500 crore extending till the year 2026. If you have to look at the funding overview of 2014 to 23, see the total funds released to National Mission for Clean Ganga is 14,084.72 crore rupees. Furthermore, the funds released by the NMCG to state agencies is 13,607.18 crore rupees. Moving on to talk about the key interventions. See, a total of 409 projects worth 32,912.40 crores have been undertaken with 232 projects completed. Furthermore, 177 sewerage projects have been initiated with a budget of 26,673.06 crores to create or rehabilitate 5,269.87 million litres per day of sewage treatment capacity and lay 5,213.49 kilometers of sewerage network. Of these, 99 projects are completed, adding 2,043.05 million litres per day capacity and 4,260.95 kilometers of sewerage network. Next, untreated wastewater remains a primary pollution cause. Hybrid annuity-based PPT models have been adopted for sustainable sewerage treatment operations. Significantly, the Central Pollution Control Board monitors water quality at 97 locations across 5 states. Know that the dissolved oxygen levels have been found satisfactory for river health and biological oxygen demand mostly within acceptable limits, except for minor exceedances at specific locations in Uttar Pradesh and West Bengal. The next article says that Supreme Court on October 17th upheld the constitutional validity of Section 6A of the Citizenship Act of 1955, which recognized the Assam Accord by 4-1 majority. Know that the 5-judge bench delivered the judgment. In this context, let us talk about Section 6A of Citizenship Act. See, Section 6A was introduced into the Citizenship Act of 1955 as part of the Assam Accord, which is a memorandum of understanding or settlement signed on August 15th of 1985 between the Government of India and the leaders of Assam government. Know that the provision was created in response to the humanitarian crisis caused by the 1971 Bangladesh Liberation War and to address the issue of cross-border migration into Assam. If you have to look at the key provisions of Section 6A, see the foreigners who entered Assam before January 1st of 1966 and were ordinarily resident in the state would have all rights and obligations of the Indian citizens. Furthermore, those who entered Assam between January 1 of 1966 and March 25 of 1971 would also enjoy the same rights, but they would not be able to vote for 10 years. So the cutoff date for determining the foreign status in Assam was established as 24th March of 1971. Interestingly, this cutoff date, if upheld, could create a conflict with the Citizenship Amendment Act, which has a different timeline and may be seen as violating the Assam Accord. The third article of the day says that Delhi's air quality continues to remain in poor category for the third consecutive day on Wednesday, with some monitoring stations recording levels that slipped into very poor and severe categories. Know that the emissions from transportation account for approximately 19.2% of Delhi's air pollution, according to the Centre's Decision Support System for the Air Quality Management in Delhi. In this context, let us talk about the Air Quality Index. See, the Air Quality Index in India is a tool designed to provide the public with real-time information about the quality of air in their localities. Know that the air quality index system categorizes the air quality into 6 levels, ranging from good, which is 0 to 50, to severe, which is 400 plus, providing an easily understandable way to assess the impact of pollution on health. So the categories are good, which is 0 to 50, satisfactory 51 to 100, moderate 101 to 200, poor 201 to 300, very poor 301 to 400, and severe, which is 401 to 500. Significantly, the air quality index is based on the concentration of 8 key pollutants, which are particulate matter 10, particulate matter 2.5, nitrogen dioxide, ozone, sulfur dioxide, carbon monoxide, ammonia, and lead. Know that each pollutant's concentration is converted into a numerical scale that reflects its health impact, and the pollutant with the highest score determines the overall air quality index for that location. The next article says that hearing a matter regarding the alleged illegal mining in Uttarakhand's Rishikesh, the National Green Tribunal has warned the Dehradun District Magistrate of possible criminal action for violating its order. In this context, let us talk about the National Green Tribunal, in short called the NGT. See, NGT is a statutory body established under the National Green Tribunal Act of 2010. Significantly, its objective is to provide effective and expeditious disposal of cases related to environmental protection, conservation of forests and other natural resources, and the enforcement of legal rights pertaining to the environment. In general, the NGT follows from the right to a healthy environment as a fundamental aspect of the right to life under Article 21 of the Constitution. Moving on to talk about its powers. See, NGT has the authority to hear and decide cases related to environmental protection, conservation of forests and other natural resources, and enforcement of any legal right relating to environment. Furthermore, it possesses both civil and criminal jurisdiction, allowing it to hear cases relating to environmental violations and offences. Additionally, NGT has jurisdiction over all the civil cases under the following acts. Significantly, the NGT outlines penalties including imprisonment up to 3 years, fines up to 10 crore rupees, or both based on the violation's nature and seriousness. Also, NGT has unique forum status, granting it the authority to take up environmental issues nationwide without awaiting specific case filings. Furthermore, the NGT can review and challenge decisions, acts, or omissions of the government or any public authority that have caused environmental harm. Lastly, what about its principle? See, the tribunal shall not be bound by the procedure laid down under the Code of Civil Procedure 1908, but shall be guided by principles of natural justice. Notably, the National Green Tribunal is headed by a chairperson who is a retired judge of the Supreme Court of India. The next article says that Chief Justice of India has recommended Justice Sanjeev Khanna to the government for the appointment as the 51st Chief Justice of India. In this context, let us talk about the Collegium System. See, it is a system of appointment and transfer of judges that has evolved through the judgments of the Supreme Court and not by an act of parliament or by a provision of the constitution. If we have to look at the evolution of the system, see, the first judges case of 1981 declared that the primacy of the Chief Justice of India recommendation on the judicial appointments and the transfers can be refused for cogent reasons. Furthermore, the ruling gave the executive primacy over the judiciary in judicial appointments for the next 12 years. Through the second judge's case of 1993, Supreme Court introduced the Collegium System, holding that consultation really meant concurrence. Also, it added that it was not a CJI's individual opinion, but an institutional opinion formed in consultation with two senior-most judges in the Supreme Court. Then in the third judge's case of 1998, Supreme Court on President's reference expanded the Collegium to a 5-member body comprising the Chief Justice of India and 4 of his senior-most colleagues. The next article says that the Reserve Bank of India on Thursday ordered 4 non-banking financial companies to cease and desist from sanction and dispersal of loans, charging them with usurious pricing and other regulatory deviations. In this context, let us talk about a non-banking financial company. See, a non-banking finance company is a company registered under the Companies Act of 1956, engaged in business of loans and advances, the acquisition of shares, stocks, bonds, debentures, securities which are issued by the government or local authority or other marketable securities of like nature, leasing, hire purchase insurance, business or trade business. Further, it does not include any institution whose principal businesses is that of agricultural activity, industrial activity, the purchase or sale of any goods other than securities, or providing any services and sale, purchase, construction of immobile property. See, generally these institutions are not allowed to take traditional demand deposits from the public. Know that they can only accept time deposits and they do not provide a savings or current account facilities further. They cannot accept deposits for a period less than 12 months and more than 60 months. Also, the NBFCs cannot offer interest rates higher than the ceiling rate, which is prescribed by the RBI from time to time. But significantly, NBFCs also provide a wide range of monetary advice like reserves and advances. Now, if we have to talk about its regulation, see, the functions of NBFCs are managed by both the Ministry of Corporate Affairs and the RBI. Furthermore, the RBI has the authority to issue licenses to NBFCs, regulate their operations, and ensure that they are established norms and regulations. Now, how are NBFCs different from banks? See, firstly, NBFCs do not have a banking license. Secondly, they cannot accept the demand deposits. Thirdly, NBFCs do not form part of the payment and settlement system and cannot issue checks drawn on itself. Next, the deposit insurance facility of the Deposit Insurance and Credit Guarantee Corporation is not available to the depositors of NBFCs, unlike the case of banks. Lastly, unlike the banks, NBFCs are not subjected to stringent and substantial regulations. The last article of the day says that after the hotly contested Lok Sabha elections earlier this year that saw the Election Commission taking action in 14 major Model Code of Conduct violation cases, the recently concluded Haryana and Jammu and Kashmir Assembly elections went off without any notices or punitive actions by the poll panel. In this context, let us talk about Model Code of Conduct. See, the Model Code of Conduct is a set of guidelines issued by the Election Commission of India to regulate the conduct of political parties and candidates during elections. Furthermore, it ensures free and fair elections by setting up standards for campaign activities and polling procedures. Now, if we have to look at the key features of the MCC, see, the objective is to maintain decorum during the elections by preventing misuse of government machinery and ensuring ethical conduct by political parties, candidates, and non-political organizations supporting them. Know that it is applicable during the general, state assembly, and legislative council elections for local bodies, graduates, and teachers' constituencies. Furthermore, it is enforced nationwide during the general elections and state-specific during the legislative assembly elections. Know that all the government bodies are bound by the Model Code of Conduct. Know that it begins as soon as the Election Commission announces the election schedule and it ends when the election process is complete and results are declared. Do you think Model Code of Conduct is a law? See, the Model Code of Conduct is not a statutory document, meaning it is not enforceable by law, but violations of some of its provisions can lead to punitive action under other laws like the Indian Penal Code and the Representation of the People's Act of 1951. Some of the actions which are considered electoral offences or corrupt practices are: firstly, causing communal or caste-based tensions; secondly, appealing to caste or religious sentiments to secure votes; thirdly, bribing or intimidating voters; fourthly, canvassing near the polling stations or transporting voters; and lastly, disrupting public meetings or serving liquor on the polling day. If you have to read further about the Model Code of Conduct, you can check out the notes on the Telegram channel. So in this video, we have discussed 8 articles in total for today. We'll be back again with another video tomorrow. Thank you.